You're on something.
Yes,
you're on something right now. What are you on?
Probably a little bit of cocaine.
Probably a bit of.
All right, folks, right out the gate, we are not easing into this. Quincy admits to cocaine use in open court, and the judge just rolls with it. But here, that's the kicker. This is untouched drama. It matters legally. Any admission like this could influence how a judge assesses flight risk bond eligibility or compliance with court orders. Wild start, Buckle.
Okay.
Welcome to Bench Report Court Cam.
Court does call the cases of the people versus Quincy Jones.
Okay, Richard McDuffie for the people.
Morning, Your Honor. Mike Getty, Assistant Public Defender on behalf of Mr. Jones, who's here to my right, Judge. State your name, Mr. Jones.
Quincy Jones.
You feel better today?
Yes, I do.
Do you?
Yes.
Sobriety's a funny thing, isn't it? Never mind. You don't have to answer that. I'll never show up here like that again. You hear me?
Yeah.
All right. What are we doing?
Yeah. Oh, I'm sorry.
Oh, I'm sorry. This was also an arraignment. The court was attempting to arraign him on the new case last time.
Right.
Yes, on the 25 F2 1290.
Okay, quick breakdown here. This is an arraignment meaning. Quincy's officially being charged in a new case. You'll hear terms like waive reading and standing. That just means they're skipping the formal reading of charges and jumping ahead, but don't let the legalese fool you. This is the court locking in the next round of accountability.
3, Your Honor, or 0697, Your Honor. Anticipating that will be appointed, I would waive reading and standing.
All right. Defendant having waived formal reading standing, you court will enter a not guilty plea as to that case. And the public defender is appointed in that matter. What date did you want me to set probable cause?
Your Honor, I did receive the police report earlier this morning. Ms. McDuffie was kind enough to send it to me. The version I got last night wouldn't open, so I haven't had a chance to go over that with Mr. Jones. I'd ask for the next available date, and if I can be heard on bond.
Yes.
Your Honor, Mr. Jones is here.
Well, hold on a second.
Oh,
I'll make it the 17th, so he's not.
Thank you, Judge.
June 17th, 2025 at 9. That's current time on the other matter, too. Go ahead.
Thank you, Judge. Mr. Jones is here in custody today, obviously. He does have a place to reside. He resides in Ann Arbor. He does have his own apartment. He does receive assistance from Avalon Housing. I was able to reach them on the phone, and they are, would continue to provide him assistance in navigating the ins and outs of life. He would comply with whatever drug testing the court would require, where sober link if the court, or a scram tether if the court required such. He does receive a monthly, I believe, shot under an ATO. I'd ask the court to give him an opportunity to have a personal recognizance bond in this matter with monitoring and whatever testing requirements that the court deems.
Notice how the public defender leans heavily into support systems. Avalon Housing, drug testing, compliance, even monthly treatment shots. This isn't just fluff. It's a strategy to humanize the defendant and signal to the judge. He's got structure. Don't jail him. Do you think support should outweigh prior behavior and bond decisions? Let me know in the comments.
Suitable.
From the people.
Your Honor, while I don't have an issue, my original request was for a $7,500 PR bond on this case. It probably goes without saying, especially at this point, that I am requesting a testing order. I don't know to what extent alcohol is something that Mr. Jones deals with, but certainly drugs, narcotics, cocaine specifically, are of concern to the people. I think that there was a request on his older file, but because he had been hospitalized and gotten out of treatment, the court declined to impose a testing order at that time. Unfortunately, I think we see that we probably need to keep.
Notice how the public defender leans heavily into support systems. Avalon Housing, drug testing, compliance, even monthly treatment shots. This isn't just fluff. It's a strategy to humanize the defendant and signal to the judge. He's got structure. Don't jail him. Do you think support should outweigh prior behavior and bond decisions? Let me know in the comments.
Post tab on Mr. Jones's compliance. Other than that, no objection to the PR and the standard.
Yes. How often are you using when you're out?
Well, I ain't not that much.
What?
Mainly not that much.
Because I was a bit surprised you did what you did last week.
I don't
No, usually you show up and you show up sober enough to take care of business.
Yeah, I had there was a lot going on between my mom's girlfriend and the house selling. And it's
All right.
Yep. Yeah.
On case ending in 575. In that case, that I've adjourned to the 17th at 9, I'm going to reinstate his previous bond of the 5,000 personal recognizance. All right, and the previous conditions. It means that you're going to have testing on that. Understood?
Yes, sir. Yes, Your Honor.
On his new matter, I'll set his bond at a $5,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons. There's to be no use of alcohol, recreational marijuana, or any illegal drug. You repeat that?
Oh, yeah.
You sure?
Yes.
I'm going to order that he test at community corrections. How often are you testing under the old order? How many times were they calling you?
Not once.
I don't believe he was
Oh, was it?
at all.
Oh, that's right.
Ah, and here comes the consequence. Drug testing twice a week. That's intermediate supervision, meaning Quincy's on a short leash. Let's be clear, this isn't overkill, it's a legal safety net. Courts use this to reduce relapse while keeping someone out of jail effective. Sometimes expensive, definitely worth it. Depends on who you ask.
So I'm going to order intermediate supervision with at least 2 times per week drug testing. Got that?
Okay.
Thank you.
Your Honor, will he need to report immediately to community corrections if he gets out or within 24 hours? Or will they come see him before?
Yes, they get him out. Community, and you're out before 4:30. I want you getting over for 4 o'clock. I want you getting over there to community corrections.
Yes, Your Honor.
Hear me?
Yes, Your Honor.
Thank you, Your Honor.
All right. Got it. Court does call the cases of the people versus Quincy Jones.
APA Rachel McDuffie for the people.
Cameron Dadish on behalf of Mr. Quincy Jones, who is approaching. Can you put it on the record?
Quincy Jones.
All right, he has a new case. You know that.
Yes, Your Honor.
New case, new chapter, same Quincy. We're right back where we started. If you've been following along, ask yourself, are we watching a redemption arc or just another loop in the system? Sound off, is the court doing enough? Or is Quincy running out of chances?
All right. So, Mr. Jones, you have a new case currently, okay? And you're before the court on a complaint that alleges that on or about March 14, 2025, at the location of South Huron in Michigan Avenue in Ypsilanti City, that you did knowingly and intentionally possess less than 25 grams of a mixture containing cocaine. Do you understand that charge? I'm not saying whether or not you did it. I'm saying, do you understand what you're charged with?
Okay.
Do you?
I understand that.
All right. That is a felony punishment